A few carefully chosen words can echo for centuries, shaping a nation's destiny in ways their authors could never fully predict. The Second Amendment to the United States Constitution is a perfect example of such powerful language. Its text is deceptively short, yet its meaning has been the source of profound and passionate debate from the moment of its inception to the present day. To understand this ongoing conversation, one must travel back in time, not just to the year 1791 when the amendment was ratified, but to the colonial era that birthed the very ideas behind it. This journey reveals a story not just about firearms, liberty, fear, and the fundamental question of where power should reside in a free society. In the 18th century, the American colonists harbored a deep and abiding suspicion of concentrated governmental power. They had lived under the authority of the British Crown, an ocean away. A key instrument of that perceived oppression was the Standing Army, a professional, permanent military force loyal to the central government. Colonists believed that such armies could be used to suppress the populace, enforce unjust laws, strip citizens of their rights. The image of British redcoats, garrisoned in their towns, was a potent symbol of this danger, a constant reminder that their freedoms were fragile and could be taken away by force. This profound fear of a standing army gave rise to a powerful counter-ideal: the citizen militia. The militia was not a professional army, but a body of ordinary citizens, farmers, merchants, artisans, who were expected to keep arms and be ready to defend their communities when called upon. This concept was deeply rooted in English history and was seen as the ultimate safeguard of liberty. A government, leaders like George Mason and Patrick Henry argued, would hesitate to impose its will upon a populace that was armed and organized. The experience of the American Revolution cemented this belief in the minds of the founding generation. The war for independence was not won by a professional army alone. It was fought and sustained by countless militiamen who took up their personal arms to resist British rule. The legendary Minutemen of Lexington and Concord, who answered the call to arms in a moment's notice, became heroic figures embodying this ideal. They were not soldiers by trade, but citizens defending their homes and their principles. This experience forged a direct and powerful link between the ownership of firearms, the duty of militia service, and the very preservation of freedom itself, setting the stage for one of America's most enduring constitutional debates. When the Constitutional Convention concluded in 1787, the new framework for the United States government was presented to the states for ratification. While many, known as the Federalists, celebrated the strong central government it created, a significant opposition emerged. These critics, the Anti-Federalists, were deeply alarmed. They argued that the new Constitution gave the federal government far too much power at the expense of the states, and that it lacked a specific declaration of individual liberties. They feared that the rights they had just fought a war to secure could be trampled by the very government they were now creating. Their voices were loud and influential, and they demanded concrete protections. To address these powerful objections and ensure the Constitution's adoption, James Madison and other leaders promised to add a series of amendments immediately after ratification. This collection of amendments would become known as the Bill of Rights, explicitly listing protections for individual freedoms. The Anti-Federalists specifically worried the federal government, with its power to raise and support a national army, might attempt to disarm the state militias, leaving the people defenseless against potential tyranny. In 1789, James Madison introduced a proposed list of rights to the First Congress, and after debate and revision it was sent to the states for ratification, completed in 1791. In the decades following the ratification of the Bill of Rights, the Second Amendment generated surprisingly little national controversy or judicial review. For most of the 19th century, life in America was largely rural, and firearms were an ordinary and unremarkable part of the landscape. They were practical tools used for hunting game to supplement a family's food supply, for defense against predators on the frontier, and for personal protection in a society that often lacked organized, professional law enforcement. The government was small and distant, and federal gun laws were virtually non-existent. During this period, the militia system remained central to the nation's defense philosophy, at least in theory. The Militia Act of 1792 required most able-bodied white male citizens to enroll in their local militia, and, crucially, to provide their own firearms and equipment. This legislation reinforced the practical link between private gun ownership and the civic duty of community defense. However, the effectiveness of these state militias was often questionable. They were frequently undertrained and poorly organized. And as the 19th century progressed, the nation began to rely more heavily on a professional standing army, especially for conflicts beyond local defense. diminishing the practical importance of the citizen militia. State governments, not the federal government, were the primary regulators of firearms during this era. While federal courts remained silent on the Second Amendment, state courts occasionally confronted the issue under their own constitutions, many of which had their own right to bear arms provisions. The American Civil War from 1861 to 1865 was a cataclysmic event that fundamentally reshaped the nation and its understanding of rights and federal power. But it was the aftermath of the war, the period known as Reconstruction, that would sow the seeds for future transformation of Second Amendment law. In the defeated South, white supremacist groups like the Ku Klux Klan emerged, state-sponsored black codes were enacted, disarming newly freed African Americans and terrorizing them into submission. This systematic disarmament was a brutal tool of oppression. In response, Congress passed civil rights acts and most importantly drafted the 14th Amendment, ratified in 1868. Its Privileges or Immunities Clause, Due Process Clause, and Equal Protection Clause were designed to protect the fundamental rights of all citizens from being violated by state governments. During the debates, lawmakers explicitly discussed safeguarding freedmen's right to keep and bear arms for self-defense against organized violence. Yet, in United States versus Cruikshank, 1876, the court held the Second Amendment restricted only the federal government, not the states. This left individuals without federal protection against state-level gun control or discriminatory disarmament. That framework dominated for nearly a century. The Prohibition era's gangland violence spurred the National Firearms Act of 1934, taxing, registering, and tracking certain weapons. In 1939, United States versus Miller upheld the law as applied to a sawed-off shotgun, finding no reasonable relationship to a well-regulated militia. For most of the 20th century, the prevailing legal consensus was that the Second Amendment conferred a collective right tied to militia service. Beginning in the 1970s and 80s, scholars, historians, and advocacy groups advanced an individual rights standard model. The showdown arrived with District of Columbia versus Heller, 2008, challenging a near-total handgun ban and in-home disassembly lock requirements. In a 5-4 opinion by Justice Antonin Scalia, the court struck down the D.C. laws affirming for the first time an individual right to possess a firearm for traditionally lawful purposes like self-defense in the home. The court read the operative clause as a personal right predating the Constitution, and the prefatory clause as stating a purpose, not a limit. Yet Heller also emphasized limits. Long-standing prohibitions in sensitive places remain constitutional. 2 years later, McDonald versus Chicago incorporated the right through the 14th Amendment, applying it to the states. With McDonald, the Second Amendment became a nationwide individual right, triggering new legal challenges across the country. The Heller and McDonald decisions did not end the national debate. They opened a new chapter. By establishing an individual right while acknowledging some regulations, the court created a vast middle ground of legal uncertainty. Since 2010, courts have wrestled with hundreds of challenges, producing a complex, sometimes contradictory patchwork. Two main viewpoints continue to define the contemporary debate, each rooted in different readings of history and constitutional philosophy. On one side, advocates emphasize self-defense as paramount and argue many restrictions on types of firearms and places of carry are unconstitutional. They stress that law-abiding citizens shouldn't be penalized for criminal acts and point to the amendment's text and a tradition of self-reliance. On the other side, advocates underscore well-regulated, and Heller's acknowledgement of limits Koskin Kramers, supporting background checks, some equipment bans, and red flag laws. They highlight the leap in firearm technology since 1791 and the realities of modern urban violence. Today, on October 16, 2025, the debate continues to unfold in legislatures, courtrooms, and the public square. Historical tradition tests are reshaping doctrine. Some laws fall, others survive. The history of the Second Amendment matters profoundly because it informs every one of these arguments. It is a story of evolving fears, from tyrannical armies to urban crime, and evolving technologies, from muskets to modern rifles. Understanding this long and contested history is the first step toward navigating one of the most defining and divisive issues in American life.